A warning. You were in here when I gave the warning. No, don't even try it. I saw how you walked out. I saw how you looked at him. I saw how you flipped your head. I didn't want to see that. I asked that everybody be respectful to everybody else. All right. So if you come back in this courtroom ever, you make sure you behave yourself accordingly. Understood? Yes, sir.
Before a single witness takes the stand, before a single piece of medical evidence is introduced, this courtroom is already on edge. And that matters, because when a judge opens a case by issuing a warning about behavior, body language, and respect, it tells you one thing loud and clear. Emotions are already running high, and this case is not going to be easy on anyone involved. This is the case of the people of the state of Michigan versus Daryl Hicks, and at the center of it is something no courtroom ever wants to deal with: the death of a 7-week-old child. A case that forces jurors, lawyers, and the judge himself to walk a razor-thin line between medical science, parental responsibility, and criminal intent. What makes this case especially complex is that there is no video, no eyewitness, no confession laying everything out cleanly. Instead, this case lives in timelines, medical opinions, credibility battles, and what didn't happen just as much as what did. You're going to hear testimony about seizures, twitching, medical visits, and delayed reactions. You're going to hear experts explain injuries that don't come from accidents, at least not typical ones. And you're going to hear a defense argue intent matters just as much as outcome. So as you watch this unfold, keep one question in mind. When something catastrophic happens to a child, how does the law decide where tragedy ends and criminal responsibility begins?
Court does call the case of the people of the state of Michigan versus Daryl Hicks.
Good afternoon, Your Honor. Marie Tanha, Assistant Prosecuting Attorney on behalf of the people.
Good afternoon, Your Honor. Sam Bernstein with on behalf of Mr. Hicks, who is approaching and is seated now.
Thank you, sir. All right, date and time, relatively speaking, for the preliminary examination. Are the parties ready?
Ready to proceed, Your Honor.
Yes, Your Honor. Thank you.
All right. Call your first witness.
Thank you, Your Honor. People called Deja Yargi McCoy.
Come forward and be sworn.
Before you take a seat, raise your right hand. You solemnly swear and affirm the testimony about the have a seat. State, spell your first and last name for the record, please.
Deja McCoy Yargi.
Can you spell that for the record, please, ma'am? Yes, please.
DEACIJAH. McCoy MCCOY-YARGE.
Okay, thank you. You may inquire.
Thank you, Your Honor. And am I pronouncing Deja? Is that right? Okay, thank you. May I call you Deja?
Yes.
Thank you. Deja, I'm going to be asking you some questions, and after I'm done asking you questions, defense counsel might ask you some questions, okay? If anything is unclear to you, if you're not hearing what we're saying, if you're not understanding what we're saying, please let us know, okay? When you're answering questions, sometimes we get used to saying instead of yes or no. Please try to say yes or no as much as you can, okay? Thank you. Deja, do you know someone by the name of Daryl Hicks, Sr.?
Yes.
Who is he to you?
My son's father.
And you see him in court today?
Yes.
Could you let the court know where he's seated and describe an item of clothing he's wearing?
To the left of me.
Okay. Can you describe what he's wearing, please? Thank you. Your Honor, may the record reflect the witnesses identified the defendant?
This moment is procedural, but legally essential. Identification locks the defendant into the narrative. There's no ambiguity about who was present, who was being discussed, or who had responsibility during the relevant time frame. From here on, every question about care, supervision, and communication attaches directly to Daryl Hicks. That matters because the prosecution's theory hinges on exclusive access. If they can establish that he was the only caregiver during the window when the injuries occurred, they don't need eyewitnesses. Circumstantial evidence fills the gap. Defense attorneys know this is dangerous territory. That's why later you'll see repeated efforts to expand the timeline, introduce uncertainty, and explore alternate explanations. Right now, though, the groundwork is being laid carefully, one brick at a time. Ask yourself, how important do you think exclusive access is in a case where no one actually saw the injury happen?
Record shall so reflect as that appears.
Thank you. And you said he's your son's father. Are you currently in a relationship?
No.
Okay. And your child, your son that you have in common, what's his name? And what was his date of birth?
July 13, 2024.
And is he currently alive? Did Darrell Jr. have a normal birth?
Yes.
Any concerns with him or you during the birth with Junior? Did Darrell Jr. have any well visits with a pediatrician?
Yes.
Okay. Were there any concerns with during those well visits? Okay. I'm going to ask you some questions about what happened late August, early September of 2024.
Okay.
It's been a while since then. So if I'm asking you a question or if the defense attorney is asking you a question and you don't remember the answer, please let us know that you don't remember, okay? Thank you. Where did you live in August of 2024? And is that Ypsilanti Township, State of Michigan, Washington County? Thank you. Who lived there with you?
My two sons.
And was one of those Darrell Hicks Jr.? How old was he in August of 2024?
A month.
And is Darrell Hicks Sr. the father of Darrell Hicks Jr.?
Yes.
How often would Darrell Hicks Sr. see Darrell Jr.?
Often.
Okay. How often would you say around that time in fall of 2024?
Close to every day.
Okay.
You said close to every day.
Yeah.
And on August 29th of 2024, did you coordinate with the defendant to have him watch Darrell Jr.?
Yes.
And did he come over to do that?
Yes.
And he came over to the house you described you living at in August. And what was the purpose of him coming to watch Darrell Jr.?
For me to go out.
And so on August 29th, what time did you leave the house?
11:30 p.m.
And was the plan to have Darrell Hicks Sr. watch Darrell Jr. overnight?
Yes.
Overnight care changes everything. It's not a quick visit. It's hours of unsupervised responsibility. Feeding, sleeping, monitoring, responding to distress. By establishing that Darrell Hicks was watching the child overnight into the next day, the prosecution strengthens its exclusive access argument. There's no overlap, no shared supervision, no confusion about who was present when decisions were made. Legally, overnight care also raises expectations. A caregiver is expected to notice abnormalities, especially in an infant. Crying, twitching, feeding issues. And if something seems wrong, the expectation is action. Call the other parent, seek medical help. This is where the case quietly shifts from what happened to what was done afterward. Audience question to consider. If you're caring for an infant overnight and something seems off, what would you expect a responsible caregiver to do immediately?
Okay, into August 30th of 2024?
Yes.
When you left the house on August 29th, how was Darrell Jr. acting at the time?
If I'm not mistaken, 29th of the month.
Okay, so I know there's some confusion about the dates. So what we're talking about is the day before ambulance had to be called and he was taken away. So the day before would have been on the August 29th, when you left the house and defendant was supposed to watch him overnight. How was he acting on the day before when you left the house? Okay. Was he eating okay throughout that day? Anything that stood out to you that was concerning regarding his body movements or how he was acting?
No.
So you said you left the house August 29th, and it was sometime in the evening. When's the next time you physically came back to the house?
The next day.
Okay. And around what time approximately did you come back to the house?
I would say 4:30, 4:45
PM.
p.m. Yes.
Before you came back to the house, so between when you left on August 29th and when you came back on August 30th, did you have any communication with the defendant?
Yes.
Okay. Was that text message, phone calls?
FaceTime.
Okay. Was anything brought up to you as a concern of how Darrell Jr. was doing?
No.
From when you left on August 29th to when you came back on August 30th, as far as you know, was there anyone else that came to the house?
No.
So defendant was watching Darrell Jr. Was your other son present at times during that time frame? Okay. On August 30th, before you came home, was there someone else there for a brief period of time? Do you remember having a visit by someone who came to check?
The day before?
Not the day before, I'm sorry, I'm confusing you. So you left on August 29th, you came back on August 30th. Before you came back on August 30th.
Yes, the pediatrician,
Okay, was it a pediatrician or was it a different?
social work. I know it's the University of Michigan, they do home visits,
Okay. And do you think it was a pediatrician or a social worker?
social work.
And do you know approximately when she was there?
12 p.m.
On August 30th, the day that you came back?
But she came back at
11, around 11. Did you ever receive any information about anyone else being at the house? Okay. So you returned on in the afternoon of August 30th. What did you observe when you came home?
This is a heartbreaking pivot point. The mother returns home expecting normalcy. And instead, something feels wrong immediately. Not panic yet, just instinct. She goes upstairs, she checks her child, and what follows becomes one of the most emotionally charged pieces of testimony in the case. The transition from sleeping to something is very wrong happens fast. Courts pay close attention to first observations. They're unfiltered, they're raw. They often shape juror memory more than expert testimony. This is also where hindsight creeps in. Things that didn't seem alarming earlier suddenly look different. Here's a question worth sitting with. How much should a court rely on a parent's instinct when that instinct only kicks in after returning home?
Sure, yeah. So when you came home on August 30th, when you came into the home, did you see anything? Did anything stand out to you?
My son was in
And when you say your son, are you talking about Darrell Jr.? Okay. He was in your room? Okay.
Yes.
Oh,
I'm sorry.
It's okay.
it happens. So you come home and how do you know that Darrell Jr. was in your room?
Because he wasn't with his dad.
Okay, and where was his dad?
in the living room.
And just to be extra annoying, when we're saying his dad, you're referring to defendant? Okay, so defendant was in the living room. Darrell Jr. was in your room.
Yes.
Okay, so what did you do, if anything, when you got home?
I came upstairs and like scanned, of course, that's how I noticed my son was in. And I went in my room to my child.
Okay, and what did you notice about your child?
He was sleeping and looked to me.
Okay. Was there anything, when you saw Darrell Jr., was there anything that caused concern?
No.
So on August 30th, when you came home, defendant was in the living room. Darrell Jr. was in your room.
Yes.
What brought you home at that time? What made you come home at that time?
Just, I miss my kids coming out all night. It was kind of like I miss my kids.
Okay. So when you come home, Darrell Jr. is in your room. Was there something that you noticed about Darrell Jr. that caused you concern?
Yes.
Okay. Can you tell the court about that, please?
I picked him up. And right from his bottom, and he started to smile near my waist. And when I reached under his head, his eyes like frozen back his head. And it's like he was changing color. Like he was shaking his arms like a lot when I tried to touch his arms with it.
This testimony lands hard, and it should. The description is specific, physical, and deeply unsettling. Eye position, muscle tension, repetitive movement. This isn't vague fear. It's observation. The mother recognizes a seizure because she's seen one before. That matters. It gives context to her reaction and credibility to her interpretation. And once a seizure is recognized, the response becomes critical. An immediate action follows with a 911 call. This moment becomes the medical turning point of the entire case. Everything before it is setup. Everything after it is consequence. For jurors, this is often where emotional alignment happens. Not with one side or the other, but with the reality of the harm. Audience question. If you were juror, would this moment alone convince you something catastrophic had already happened? Or would you still need the medical experts to explain why?
My brother had silent seizures in my sibling, so I know what a seizure looks like when it's happening. So I could tell he was seizing.
So he was having a seizure. Okay. And you described, you kind of showed your arm like moving back and forth pretty quickly.
Yeah.
And is that what Darrell Jr.'s arm was doing?
Yes.
Okay. And then you said it kind of tensed up.
Yes, it felt like it's tense.
Okay. So at that point, you knew he was having a seizure.
Yeah.
Okay. What's the next thing that you did, if anything?
Call 911. And of course, as Jurors senior, what happened?
Okay. And did he say anything about what had happened?
No.
Did you have any, how were you feeling as this was happening? Okay. What were you confused about?
Because I didn't leave.
So when you left him on August 29th, his arm wasn't twitching, it wasn't tense.
He was
Okay. Do you remember if defendant Darrell Hicks Sr. Had communicated with you throughout the day on August 30th that Darrell Jr. wasn't eating properly or keeping food down?
No.
Okay. Would it help refresh your recollection if you saw your statement to police? Okay.
This is a pivotal procedural moment. When a witness's memory appears inconsistent, attorneys can refresh recollection using prior statements. It's not impeachment, yet. It's clarification. What's important here is transparency. The prosecutor asks permission. The judge allows it. Defense counsel is shown the document first. This preserves fairness and keeps the record clean. When the witness reviews the statement and then changes or clarifies her answer, jurors are forced to evaluate credibility in real time. Is this correction honesty or influence? Legally, refreshed recollection is common. Human memory fades, especially over months involving trauma. But strategically, it's risky. The defense will later argue that the witness's memory is not independent, that it relies on documents rather than lived recall. When this moment doesn't sink or save the case, but it plants a seed, and seeds matter in jury deliberations. Audience engagement. If a witness needs to review a police report to remember details, does that make their testimony stronger or weaker in your eyes?
I may have one moment, Your Honor. Your Honor, if I may approach, this is page 6 out of 15. It's a supplemental report number 3. I'm showing it to counsel before. May I
Yes,
approach?
you may.
Thank you. So I'm going to have you just read that. Don't read it out loud, just to yourself. And then when you're done reading it, let us know. Fresh recollection. Thank you. So I'll ask it again. Did the defendant communicate to you that there were concerns about Darrell Jr. throughout the day of August 30th?
Yes.
Okay, and what were those concerns?
That he wasn't eating any shake.
Thank you. Your Honor, may I approach the retrieve
Yes.
report? Thank you. Did you have, when you came home and saw your baby and you explained already Darrell Jr. had some clear signs of a seizure, do you remember saying anything to the defendant?
Yes.
Okay, and what did you say?
This is one of the most emotionally charged lines in the entire transcript. What did you do? Is not a medical question. It's an accusation born from fear. Legally, though, the response matters more than the question. The transcript shows he responded, but the content of that response becomes a contested issue later through police statements and cross-examination. From a jury perspective, this is where emotional judgment often kicks in. People imagine themselves in that moment. Panic, anger, desperation. But courts don't decide cases on imagined reactions. They decide them on evidence. And here, the evidence becomes fragmented across testimony, police reports, and expert interpretation. This is also where defense strategy sharpens. They will argue that emotional confrontation does not equal factual clarity. What someone feels happened is not proof of what did happen. Audience question: if you were accused in a moment of chaos, would you even know how to explain yourself clearly?
You asked him what he did? Did he respond to you?
Yes.
Deja, from when Darrell Jr. was born until he passed, other than this incident, was he involved in any, like a car crash or anything, any accidents, anything like that? Thank you. Nothing further at this point, Your Honor.
All right, cross-examination.
Deja, may I call you that as well? My name is Sam Bernstein. I'm Mr. Hicks's attorney. I'm going to be asking you a series of questions, just like Ms. Tanhut. Some of them might be similar to what you've already answered. It's just part of the process, okay? So you and Mr. Hicks had like a co-parenting relationship?
Yes.
And could you describe that for me, please?
I worked, you worked, so 4 days.
You said you flipped days? Like you alternated who took care of Terrell Jr. on which day? Like you switched over every other day?
Yes.
Okay. And I think your testimony was that he saw Darrell Jr. like close to every day?
Yes.
Would you describe him as being involved in Darrell Jr.'s life?
Yes.
Did Mr. Hicks know Darrell Jr.'s routines? Did he know like when the baby slept, when the baby had a bottle?
Objection, Your Honor. She can't testify as to what Mr. Hicks knew, so maybe if the question can be repeated.
For yourself, yeah.
Did you observe Mr. Hicks? Like, did you see with your own eyes him care for the child?
Yes.
And based on what he was doing, did it look like he, knew when the baby slept?
Yes.
Did he know how to change the baby's diaper?
No, you have to learn.
Sure. No, I know. We have to learn how to change a diaper, but did he eventually learn how to change a diaper?
Yes.
And did you see him give the baby baths?
Yes.
And did he feed the baby as well?
Yes.
Did you see Mr. Hicks knowing like what Darrell Jr. would eat as far as the bottles go? Were you comfortable with Mr. Hicks watching the baby?
Yes.
Excuse me one more. Alan, can you check that hallway and tell us if they need to quiet down? Is it over there? Thank you. Go ahead.
Feels like the PD's judge. I mean, what about what Mr. Hicks was doing that made you comfortable with him watching Darrell Jr.? Had you ever seen Mr. Hicks handle his son in like a rough manner?
The defense locks in a critical point here. No prior roughness, no yelling, no visible abuse. That matters because it eliminates pattern evidence. There's no history of violence being introduced, only a single catastrophic event. From a legal standpoint, absence of prior abuse doesn't equal absence of guilt, but from a human standpoint, it complicates judgment. Jurors naturally ask, if this person were abusive, wouldn't there be signs? This is where expert testimony later becomes crucial. Medical experts will explain that abusive head trauma can occur in a single episode, often during moments of frustration. No long history required. But at this stage, the defense is winning emotional ground. Ask yourself, would you expect to see warning signs before something like this? Or can one moment change everything?
No.
Did you ever see Mr. Hicks like yell or shout at the baby? You have a son named Caden as well?
Yes.
And Caden was like 4 years old at the time? And did Mr. Hicks supervise Caden as well sometimes?
Yes.
Did Mr. Hicks have like something of a relationship with Caden too? Like they knew each other somewhat, yeah. Would Mr. Hicks supervise the baby and Caden at the same time?
Majority of.
Would you already know? Okay, but sometimes?
Yes.
How often would they do that? Okay. And obviously, Caden was with Mr. Hicks for a little bit the evening that you went out, right?
Yes.
How long was Mr. Hicks watching Caden and Daryl Jr. that evening that you went out? Okay, so Caden was there the whole night? The next morning, you're still out. There's a social worker that comes over, right?
Yes.
You said the social worker came over at 11 or noon?
She was supposed to come in when she came.
She came at 11. Between the time that you left that evening and the next morning, you had communicated with Mr. Hicks?
Yes.
What types of communications did you guys have?
Before we went to bed. And he was putting him in bed.
Do you know how many FaceTimes did you guys have?
That day.
Well, between the time that you left and when, and 11 o'clock the next day.
It was two. One before bed, and then one with the social worker. Person.
FaceTime with a social worker?
Yes.
Okay. Did Mr. Hicks send you communications outside of FaceTime?
No.
Were there any like phone calls or text messages? How many times did you guys call? Sure, that's fair. I know it's a long time ago. Do you remember what you guys talked about on those phone calls?
And the next day with the social worker, and we talked something.
So the next morning after the overnight and before the social worker came over, did you talk with Mr. Hicks that morning? Did you talk with Mr. Hicks before the social worker came over? When's the first time that you heard about the arm twitching? You're saying the first time that you heard about the arm twitching is when you found your son later the afternoon that you came home? Did you talk about the arm twitching with the social worker? After what?
Before I need to go. I asked questions. Yeah.
Would it help refresh your memory if you like saw the police report where you talked to the detective about all this, like you did with Ms. Tanha?
Yeah.
Okay. It's 8, but it might be like 6 to 8.
Did you need a break, ma'am?
Yeah.
Okay, all right. Okay, go ahead. You can step down. We're back on the record in the case of the People versus Hicks. Witnesses on the stand. Ma'am, I just need to remind you, and I'm sure you know, you're still under oath. All right. And if you, even though it seemed like you just did, but if you need another break, you just say so. All right. We'll do what we can. Okay.
Okay.
All right.
Thank you.
You're welcome. To those that are in the courtroom, after I had left the bench, there were certain reports to me. I'm not going to get into all the details or who did what along those lines, but I'm just going to say this. I expect that everyone will have proper decorum while they are in this courtroom. There will not be any yelling back and forth or going at each other in any way. If I get any hint of that, I will have you removed.
Judge Simpson steps in again. And this time, his words carry gravity. He acknowledges how hard this testimony is for the witness, regardless of where you stand on this. That's judicial neutrality in action. This warning also protects the witness. Emotional reactions from the gallery can intimidate or re-traumatize someone already struggling to testify. By shutting that down, the judge preserves the integrity of the process. It's also a signal to jurors: focus on evidence, not emotion. This case will be decided by facts, expert testimony, and law, not reactions from the room. As we move forward, the case will transition from memory-based testimony to expert analysis. Science will begin to replace perception. And that's where things become even more intense.
And I will make no bones about it. This is the only warning that you're going to get. This is tough enough, quite frankly, for this witness to testify to, regardless of where you stand on this. And that this other stuff is just not needed, and I will not be having it. So I hope everybody understands that, understands my admonition to you, and understand that I will enforce it. Mr. Bernstein, you may continue your cross-examination.
Yeah, I was asking you about the first time that you heard about Darrell Jr. shaking or twitching. And I think where we left off, I think you had said that the first time you noticed twitching or shaking was when you came home that day.
Yeah.
And I wanted to refresh your memory. Is it possible that you spoke with Mr. Hicks and the social worker about the twitching at the time of the home visit?
No, I do not.
Would it help refresh your memory if I showed you what you said to the police when you spoke with them? Your Honor, may I approach after showing this?
Yes.
After looking at that, do you have a better recollection of the timeline there?
Yeah. Yes.
Yeah, so do you remember a conversation with Mr. Hicks and the social worker about twitching and shaking?
Just to clarify, it wasn't a conversation with the social worker present, it was just me and him on the phone. She wasn't there.
Okay, so you had a conversation with Mr. Hicks on the phone about the shaking? When was that?
That was like, literally, she was walking out of the door and he called. She wasn't present to clarify that it was his nerves. That's what he told me.
This moment tightens the defense's theory. The witness clarifies that the conversation about twitching happened between her and the defendant, not with the social worker present. That distinction matters. If a professional didn't hear or validate concerns directly, then the defense can argue the defendant relied on his own interpretation, rightly or wrongly. It shifts responsibility away from institutional oversight and back onto personal judgment. But this also cuts the other way. If concerns were discussed privately and still no action followed, the prosecution can argue that the defendant chose reassurance over urgency. This back and forth illustrates why child abuse cases are among the hardest to decide. They live in gray areas of judgment, not clean lines of intent. Like audience engagement. If someone tells you a symptom is just nerves, would you accept that or insist on a hospital visit anyway?
I mean, did you tell the officers that you got a call from Senior and the at-home nurse stating that Junior was shaking?
No,
Did you tell the detectives that, that you were told that Junior's arms were twitching?
No.
Do you remember having a conversation with the social worker that you were told that it is normal for babies to do that for the development of their nervous system? Do you remember telling the detective when you spoke with him that in speaking with the social worker, you were told that it's normal for babies to do that for their development of their nervous system?
yes,
Okay, so there was a conversation with the at-home nurse about the twitching.
after the fact, all of this occurred and going to the hospital. Yes, that was discussed.
Did you discuss it? Did you discuss it with the at-home nurse?
Not that they know.
Did you have a FaceTime conversation with the at-home social worker?
No.
Okay. Did you have any
You said
conversation?
at-home nurse, and then you said social worker, are we talking about the same person?
Yeah.
We are, Your Honor.
I just want to make sure his question is directed.
She's technically a social worker, but everyone in the report calls her a nurse, so it's just a little
That's
confusing.
fine. I just want to make sure that we're talking about the same person.
Okay. So you don't remember having any conversation with Mr. Hicks and the social worker together about twitching? You don't remember? Is it possible that you did? Is it your testimony that the first time you heard about the twitching was Mr. Hicks telling you later after the child went to the hospital?
Yes.
You testified earlier when Ms. Tanho was asking you questions that you went home because you wanted to see your baby because you missed him? Is it possible that you went home because you were concerned about some twitching and shaking?
This question goes straight to motive, not the defendant's, but the mother's. Defense counsel is probing whether she returned home due to concern rather than simple longing. Why does that matter? Because if she returned out of concern, it suggests prior awareness of symptoms, which weakens the prosecution's claim of sudden discovery. The witness attributes her decision to intuition and faith. That answer is emotionally compelling but legally ambiguous. Courts respect belief, but they evaluate actions. This exchange highlights a recurring theme: instinct versus evidence. Human intuition doesn't fit neatly into legal frameworks, yet jurors are human first. Audience question: should instinct and faith influence how we judge timelines in a criminal case, or should they be set aside entirely?
No.
Did you talk to the detective about, I kept hearing my baby crying in the back of my mind and felt that I needed to go home and check on him?
Yes.
Okay, so why did you tell the detective that?
Because I believe in God and I feel that God was calling me to go get my son. I don't know why, but randomly, yes, it happened.
Okay. Is it possible that you said those things because you were told by people that your baby was twitching and that you needed to go check on him?
No, I was never told he was twitching or nothing.
When you spoke with Detective Yeager, you said that you didn't have any concerns that Mr. Hicks did anything to the baby?
No.
You didn't say that?
Wait,
Did you tell the detective when you spoke with him that you did not have any concerns about Mr. Hicks doing anything to the baby?
no.
You didn't say that? Do you,
Wait, when you say concern, you mean like in a moment of something happening to my son? No.
Okay.
I wasn't concerned. That's his father.
This answer is powerful and complicated. The mother states she had no concern the defendant harmed the child. For the defense, that's gold. For the prosecution, it's a hurdle. However, courts understand that parents often struggle to reconcile harm with familiarity. Trust doesn't negate reality. It reflects relationship dynamics. Legally, a parent's belief is not determinative of guilt or innocence. But emotionally, jurors may find it difficult to convict someone the mother herself didn't initially suspect. This is where expert testimony becomes essential. Separating emotional trust from forensic evidence. Ask yourself, how much weight should a parent's belief carry when medical science points elsewhere?
I want to go back to, you stated, I had asked you about talking with a detective and talking about some of the things that you said about what might or might not be normal for babies to do. Did you read that when I gave you the police report? No?
I'm all over the place, trying to take everything.
I understand. Wait, did you say you want me to refresh your memory?
Yes.
Okay. Let me just show. Yeah. Your Honor, could I approach?
You may.
We're almost done. So look, I'm not trying to like beat you up here. We're just trying to figure out the timeline of everything, okay? I mean, after reading it, does that help refresh your memory that you may have had a conversation with the at-home nurse and Mr. Hicks about the baby twitching or shaking and whether it's normal or not?
All I remember is he did call me and she had got there. he hung up what she talked to me. So whatever him and the nurse discussed, I wasn't on the phone, is what I'm telling you. She never said nothing to me. It came out of the real senior mouth, what she said.
So when you told the detective that you got a call from senior and the at-home nurse, which were your words, stating that Junior was shaking, that what you said is false?
I'm gonna,
Oh, is it,
if we can just, I think there's some confusion, so.
There is.
Phrase.
hold on a second. Go ahead. Ms. Tanner, go ahead.
If Mr. Bernstein could kindly rephrase, I think we could get, and kind of get straight to the point, of asking a direct question, maybe that would.
All right. And if we could, Mr. because I think some of the questions also can have double answers, and I don't know if she's answering what's contained within the question or the question itself, which is making it difficult for me to follow.
Mhm.
So,
Well, let me just,
Sorry, and while I'm objecting, there's been a lot of hearsay and I've kind of let it go to
Yes.
develop testimony, but please be mindful.
well, I'm not offering anything for the truth of the matter. I'm just figuring out the general timeline. Let me just phrase it like this, and maybe this will cut it off. Did you have any conversation whatsoever with the at-home social worker that day?
No.
Okay. Thank you, Your Honor. I don't have a question.
thank you. Any redirect?
Deja, you're doing okay to keep going for a little bit? Okay. Deja, how do you feel about being here today to testify?
The witness answers simply, angry. That word carries layers. Anger at loss, anger at uncertainty, anger at being questioned. The prosecution allows this moment because it humanizes without overreaching. It reminds jurors that testimony isn't scripted, it's lived. But anger can cut both ways. Defense counsel may later argue that anger clouds objectivity. Prosecutors may argue it reflects unresolved trauma. This is the emotional ceiling of lay testimony. From here, the case transitions into experts, where emotion gives way to anatomy, imaging, and pathology. Audience engagement. Do emotional reactions make testimony more real or more unreliable to you?
Angry, betrayed.
This was fall of last year. Do you feel like you have a clear memory of everything or some things a little fuzzy?
Some things are fuzzy.
Defense counsel asked about defendant watching your son Caden sometimes as well.
Yes.
Before this incident, were you comfortable with him watching Caden?
Yes.
Had Caden indicated to you in any way that he was uncomfortable with defendant before this incident?
Hold on, what? Did Caden say something? My objection is hearsay, Your Honor.
Well, I don't know. It's going to be offered for the state of mind. I'm going to allow it.
Thank you. Do you want me to ask the question again? I know it's a lot. Had Caden in any way indicated to you that he was concerned about defendant being around him or watching him before this incident?
No.
Did that change after this incident?
Yes.
No further questions, Sharon.
All right. I just have one question for you. Man, when you came home, you said that you went into your bedroom,
Yes.
right? Where was the baby at that point?
On my bed in his body pillow.
Got it. Okay. So it was on your bed and, okay.
Yes.
Thank you. All right. Any questions based on the court's questions?
Here.
All right. Ma'am, you may step. Thank you.
Brother, may this witness be excused?
Any objection?
No, Your Honor.
This witness is excused.
People call Dr. Carla Parkin Joseph listening.
Doctor, if you could please come forward and be sworn.
Take a seat, raise your right hand. You solemnly swear to affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
See, state and spell your first and last name for the record, please.
My name is Carla Parkin Joseph, CarlaParkin-Joseph.
Humane Corps.
Thank you, Your Honor. Dr. Parkin Joseph, could you please tell the court where you're employed and in what capacity?
I am employed at Michigan Medicine, the C.S. Mott Children's Hospital. I am a child abuse pediatrician on the child protection team there.
Thank you.
This is a heavyweight witness. A child abuse pediatrician isn't just a doctor. It's a specialist trained to distinguish accidental injury from inflicted trauma. The prosecution spends time on credentials because expertise equals credibility. Jurors are more likely to trust conclusions when they understand the depth of training behind them. This witness will become the scientific backbone of the state's case. Audience question: when experts testify, do you focus more on their credentials or on how clearly they explain their conclusions?
Are you a licensed physician in the state of Michigan?
Yes, I am.
And are you board certified?
Yes, I am.
Could you briefly tell the court about your educational and training history?
Yes, after my undergraduate studies, I completed my medical degree at the University of Toledo College of Medicine in 2010. From there, I went on to my general pediatric residency training at the Children's Hospital of Michigan in downtown Detroit. I stayed an additional year after that 3-year training program as a chief general pediatrics resident, and then continued my training in Philadelphia from 2014 to 2017, and that was for my fellowship training in child abuse pediatrics. I completed that in 2017 and then came back to Michigan and have been at my position at the University of Michigan since 2017.
Thank you. Your Honor, may I approach?
You may.
Before I do so, I'm showing defense counsel Dr. Parkin Joseph's CV, which has been sent to him already. Doctor, I'm going to hand you what's been marked as people's proposed exhibit number 1. Could you please tell the court what that is?
This is my curriculum vitae.
Thank you. Your Honor, at this point, I would move for admission of the doctor's curriculum vitae.
Objection to that.
All right. Exhibit 1 is admitted.
Thank you. Your Honor, may I publish it to the court?
Yes.
And doctor, have you testified in court before?
Yes, I have.
Approximately how many times?
At least 50.
And have you been qualified as an expert before?
Yes, I have.
In what field?
In child abuse pediatrics.
And have you been qualified in child abuse pediatrics in this county previously?
Yes, I have.
Your Honor, at this point, I would move to qualify the doctor as an expert under MRE 702.
Could I just ask?
Objection of order.
Could I widen your room?
You may.
Do you want to come up here?
Sure. Just a second. Oh, yeah. Thank you, doctor. Just some general questions. So could you define for us the field of child abuse pediatrics, please?
Yeah, so it is now the American Board of Pediatrics certified fellowship training. So it is a subspecialty within pediatrics.
Once qualified, the rules change. This witness can offer opinions, not just observations. That's huge. Expert opinions allow the prosecution to connect medical findings directly to conclusions about abuse. Without this step, the case would collapse into speculation. From here on, the courtroom moves into the most technical and most decisive phase of the hearing.
That focuses on all types of child maltreatment. So physical abuse, sexual abuse, neglect, medical child abuse, all types of maltreatment, and the evaluation, diagnosis, and treatment of those conditions.
Okay, so your patients are children that are the victims of suspected abuse?
Yes, suspected victims, yes. And
Okay.
I'm providing an opinion regarding whether abuse and neglect played a part in that child's clinical institution.
You're trained in like the different mechanisms of abuse, like how this stuff happens and how it relates to the body?
Yes,
Okay. And your training enables you to kind of piece together what may or may not have happened in any way?
potentially, yes.
Okay. Well, when you say potentially, what do you mean exactly?
So at times there is a history that is provided or a potential mechanism of an injury, which I would kind of relate to the medical knowledge in the field to see if those injuries are consistent, with the ultimately diagnosed injuries as well. So sometimes there is a history that is provided to at other times, probably more difficult is when there is no history in order to really pinpoint an exact cause.
Okay, that's fair. And so if there's no history provided, there might be some limitations on your ability to say something.
Yeah.
Okay. Thank you. I'll have more later, but Judge, I have no objection.
All right.
Proposed.
Without objection, the doctor is so called.
Doctor, were you involved in evaluating a patient named Daryl Hicks Jr.?
Yes.
And how old was he when the case came to you?
I believe he was 7 weeks old.
This exchange marks a decisive turning point in the case. Until now, the court has heard from caregivers and investigators, people whose memories, perceptions, and emotions are all subject to challenge. But this question establishes something far more concrete. Dr. Carla Parkin Joseph personally evaluated Daryl Hicks Jr. while he was still alive. That matters because this isn't a retrospective opinion formed after the fact. This evaluation happened during active medical intervention when decisions were being made in real time. Jurors often place tremendous weight on first-hand medical evaluation because it strips away speculation and centers the discussion on observed clinical reality. Equally important is the child's age, 7 weeks old, a non-mobile infant. That fact alone drastically narrows the range of plausible explanations for injury. Babies this young cannot roll, crawl, or generate meaningful force on their own. Any severe injury automatically raises questions about external force or failure of care. This testimony begins anchoring the prosecution's case in objective medicine rather than interpretation, and from this point forward, emotion takes a back seat to anatomy, physiology, and biomechanics.
When and how did the case come to you?
So the case was brought to my team, the child protection team, after he had been admitted to CS Mott Children's Hospital and other medical professionals had concern for physical abuse as a cause or as a due to the injuries that were identified in Daryl.
And I'll ask you some questions about that, but before I do, did you personally observe Daryl Hicks Jr.?
Yes, I did.
Your Honor, if I may approach, before I do so, showing defense counsel People's Proposed Exhibit number 2. May I approach?
Yes, you may.
Doctor, I'm handing you People's Proposed Exhibit number 2. If you could please tell the court if you recognize what that is.
Yes, this is a photograph of Daryl in his hospital bed. And this is what he looked like at the time I observed him.
And when you say Daryl, are you referring to Daryl Hicks Jr.? Just to be clear. Thank you. Your Honor, I would move to admit People's Proposed Exhibit number 2 at this point.
Any objection or voir dire?
None, Your Honor.
Exhibit 2 is admitted. Thank you.
So when you saw Daryl Jr., what did you note upon seeing him or examining him?
So he did have many medical interventions that were already in place. So he had EEG, which is electrodes that are placed on the scalp in order to monitor brain activity. He also had a monitor that was actually placed inside his skull operatively to monitor pressure inside his skull. He was intubated and mechanically ventilated, so he had a tube placed down his throat in order to help him breathe.
This description is clinically devastating and legally powerful. These are not precautionary measures. These are emergency interventions reserved for catastrophic brain injury. Intracranial pressure monitoring is used when doctors fear the brain is swelling to a life-threatening degree. Mechanical ventilation is required when a patient cannot protect their own airway or breathe adequately. For jurors, this testimony reframes the entire case. Whatever occurred was not subtle, ambiguous, or borderline. The child was critically injured to the point where his brain itself was in danger of being crushed by swelling. From a legal standpoint, the severity of intervention undermines arguments about harmless accidents or minor mishaps. Defense theories about momentary lapses or benign causes now have to account for why such extreme medical responses were necessary. This is also where emotional reactions must be set aside. The law doesn't care how heartbreaking this sounds. It cares what these interventions reveal about the magnitude of injury. And the magnitude here is undeniable. Audience reflection. Does hearing the level of medical intervention change how you interpret everything that came before?
And had a number of other vascular lines, so IVs and other access.
Thank you. And what was the process in evaluating him medically? Could you tell us about that?
So in addition to my physical examination, I also gathered history by reviewing medical records. So what was available in the University of Michigan medical records. Also reviewed laboratory testing, so blood work that had been completed, as well as radiology studies. Daryl Jr. had a CT scan of his head, MRI of his brain, had X-rays performed as well. So I reviewed those personally and with a radiologist as well.
I want to kind of take them one at a time. So you mentioned the CT scan. Could you tell us what the results of the CT scan indicated?
So the CT scan was performed just a few hours after Daryl Jr. had presented to the hospital. And that CT scan showed evidence of swelling of the brain, in addition to some scattered areas of bleeding or hemorrhage inside the skull that appeared to be between the surface of the brain and the inner surface of the skull.
And what did those injuries indicate to you? What would those suggest?
So the bleeding inside the skull would suggest potentially some trauma. And then with the swelling and the signs of poor blood flow and oxygen flow to the brain would again suggest that there was some injury that occurred.
What did you do next after the CT scan, or what was done next?
So after the CT scan, Daryl Jr. was admitted to our pediatric intensive care unit. And just a few hours after that, actually into August 31st, he had an MRI of his brain as well.
And what is the purpose of the MRI following the CT scan?
So there are some limitations to the CT scan. It does not give great pictures of the brain tissue itself. Just to get a clearer picture of the injuries that we're seeing inside the skull, and also again to look at that brain tissue to see if there were any additional injuries.
And what were the results of the MRI?
So it confirmed again that there was bleeding or hemorrhage between the surface of the brain and the inner surface of the skull. And again, showed evidence of poor blood flow again and poor oxygen delivery to the brain.
The MRI doesn't just confirm the CT findings, it explains their consequences. Poor oxygen and blood flow mean the brain was actively dying. This is not a static injury, it's a cascading medical crisis. Legally, this matters because hypoxic ischemic injury often follows swelling caused by trauma. The chain is clear. Force causes injury. Injury causes swelling. Swelling cuts off oxygen. Oxygen deprivation causes irreversible damage. This also tightens the timeline. Severe hypoxic injury does not develop quietly over days. It escalates rapidly. That medical reality aligns closely with testimony about sudden seizure activity. From this point forward, timing becomes the battlefield. The defense must now argue against a biological process that doctors say unfolds quickly. Audience question: if science shows rapid deterioration after trauma, how does that affect your view of delayed medical response?
there was, pretty diffuse brain injury at that point.
And did that confirm what the CT scan had shown? And did that provide any additional information on top of the CT scan, or is it more of a confirmation?
More confirmation.
And what was the next procedure after the results of the MRI came back?
So I believe that he had the X-rays done next. We call that a skeletal survey. So it's a set of X-rays, usually about at least 20. That looks at all of the areas of his body, so from his skull all the way down to his toes and hands, and to evaluate for any skeletal injury, any fractures, broken bones.
And was there anything concerning on the X-rays?
In Daryl Jr.'s right tibia, which is the bone that you can feel in the front of the shin, but down at the end nearest his ankle, there was a bony fragment that was seen on the X-ray that suggested potentially that there was a fracture at the end of that bone.
Did you also, what did you do after the X-ray was completed?
So I believe after the X-ray that Gerald Jr. was taken to the operating room with the pediatric neurosurgery team. And that is when that monitor was placed inside his skull to monitor the pressure inside.
And what was that monitor indicating?
So at the time that it was placed, the goal would be for the pressure to be approximately 15 millimeters of mercury, but at the time of its placement, it was, I believe, the mid-20s. So it suggests that there was certainly increased pressure inside his head.
Was there also an eye exam conducted?
Yes, there was.
Okay. And could you tell the court the results of that eye exam?
So the pediatric ophthalmology team evaluated Gerald Jr. And they found hemorrhaging or bleeding in the retina, which is at the back of the eye, in both eyes. Those areas of bleeding in the retina were diffuse, just meaning widespread, and really covering all of the retina. They were very numerous, too numerous to count even.
Retinal hemorrhages of this nature are not subtle findings. They are dramatic, extensive, and medically significant. Doctors associate this specific pattern with acceleration-deceleration forces, the brain and eyes moving violently within the skull. This testimony is critical because retinal hemorrhages help distinguish abuse from accidental injury. Minor falls and benign handling do not produce this pattern. Defense counsel will later challenge the shaken baby diagnosis, as they often do, but the extent and distribution described here severely limit alternative explanations. From a jury perspective, this testimony often becomes a cornerstone. It connects biomechanics with visible injury. Audience reflection. When experts describe an injury pattern as highly specific, how skeptical should jurors remain?
Visualize each of the spots of bleeding, each of the hemorrhages. And they were also in multiple layers of the retina. So they were just very widespread.
And based on your training and experience, what does that suggest to you?
So that pattern and the nature of those retinal hemorrhages is most consistent with an abusive etiology that is seen typically with an acceleration, deceleration type injury.
Is that what's referred to as kind of shaken baby or a shaking movement?
Yes.
You mentioned that you reviewed other medical records. Did you review birth records for Daryl Jr.?
Yes, Daryl Jr. was born at the University of Michigan, so there was access to that information as well as his pediatrician records as well.
And was there anything from the birth records or the pediatrician records that indicated any concerns related to or would be associated with the injuries that you saw?
Really a normal delivery and really normal pediatrician.
And when you say pediatrician records after, are those like well visits essentially?
Yes.
For the baby? And those were normal as well?
Yes.
After evaluating Darrell Jr., reviewing the medical records, taking the history, putting it all together, did you have a diagnosis?
It was like a diagnosis.
Okay. And what was that diagnosis?
Abusive head trauma or physical abuse.
This is the prosecution's medical conclusion, delivered carefully and professionally. The doctor does not assign blame. She does not speculate about intent. She states what the injuries indicate. That restraint matters legally. Experts are not fact-finders. Their role is to explain the body, not the behavior. This diagnosis synthesizes everything presented so far: brain swelling, bleeding, retinal hemorrhages, hypoxic injury, and fracture. Individually, each finding raises concern. Together, they form a cohesive medical narrative. From this moment on, the defense's task becomes much harder. They must now persuade jurors that a diagnosis grounded in peer-reviewed medicine is wrong or incomplete. Ask yourself, what kind of evidence would you need to reject a medical conclusion this comprehensive?
Could you please tell the court what injuries were specifically consistent with the diagnosis of abusive head trauma?
The inside the skull that I described, as well as the diffuse swelling of the brain, likely secondary injury to the brain as a result of that lack of blood flow and lack of oxygen delivery to the brain, as well as the retinal hemorrhaging. Again, it was of a pattern or nature that would be most consistent with abusive head trauma. And then ultimately, with further imaging, there was also confirmation of the fracture described at the on the right tibia.
And with the confirmation of the fracture, what's that indicative of when you see a fracture like that in a case like this?
So this particular fracture was just described as a corner fracture, which just meant that it looks like there was a chip off the corner of the bone. But at that location, typically those types of fractures are due to some shear forces at the joints, as well as tension, so almost pulling apart of that joint as well. So in the medical literature, those particular types of fractures are highly specific for abusive injury, and they have been reported to be associated with shaking.
Corner fractures are not controversial in pediatric medicine. They are widely recognized as markers of force applied to a limb, pulling, yanking, or violent movement. This injury links the head trauma to bodily trauma, reinforcing the idea that the injuries are not isolated. It also undercuts theories involving accidental drops or benign handling. Legally, specificity is powerful. The more specific an injury is to abuse, the less room remains for alternative narratives. Audience question: does medical specificity carry more weight than witness testimony in your mind?
So that the extremities are kind of flailing, and then that produces those tensile and shear forces at the joints that would cause these types of injuries. At other times, the corner fractures have also been described from like a yanking on an extremity, or even picking an infant up by that extremity. So almost using that extremity as like a handle or lever.
Okay. In these types of cases, when a patient is presented to the hospital, do you instantly look for, was this abusive or not, or do you start in a more general fashion?
So yes, the medical team definitely started with a more broad differential diagnosis. So thinking about all the possibilities that could lead to the seizure-like activity that Darrell Jr. actually presented with. So there was consideration given to other neurologic causes of seizures. If you have, epilepsy or some kind of seizure disorder that might be causing this. There was consideration given to infection. So it's placed on antibiotics as well. But again, the imaging that was done really pointed towards.
Thank you. And based on your training and experience, what's the relationship between the severity of the injuries and onset of symptoms?
So in abusive head trauma, the more severe cases will typically present more immediately.
This statement collapses extended timelines. Severe abusive head trauma does not wait days to announce itself. It declares itself quickly, through seizures, altered consciousness, or respiratory failure. This medical principle directly impacts legal responsibility. If symptoms should appear quickly, then the window of injury narrows. And when that window narrows, so does the pool of potential caregivers. Ask yourself, how important is timing when determining responsibility in a case like this?
So closer in time frame to their development.
And was this a case you would, where the injuries would be classified as severe?
Yeah.
One moment.
Yes.
Nothing further right now. Thank you.
All right. Cross-examination.
Doctor, I'm going to pick up where Ms. Tanha left off. We talked about, or she talked about the onset of symptoms. And it seems like, is it possible that twitching or shaking is one of the symptoms that might go along with these types of injuries?
Yes.
How long would you estimate that the onset of twitching or shaking would arise after such an injury like this?
I would say my best guess would be hours at most, but could be even shorter as minutes after an injury.
Okay. How many hours, like at the maximum?
With like seizure-like activity, I would say maybe up to 24 at most.
Okay. When that twitching or shaking is observed, I mean, is it fair to say that it's important to bring a child to the hospital right away?
Yes, if there's seizure-like activity like that.
In looking, in one of the, something that happens along with the injuries is that the brain doesn't get oxygen, right? And that can result in further injuries.
Correct, yes.
In your notes, in the medical records, it seemed like you had a concern for medical neglect.
Initially, yes.
You thought that Darrell Jr. had evidence of hypoxic ischemic brain injury.
Yes.
Could you explain that?
So hypoxic just means low oxygen, and then ischemic meaning that there's no blood flow. So
Okay.
what I was describing, I just didn't use those ones.
Sure. It seems like in your notes, you stated that injury presented at the time that he came to the hospital.
Yes.
And in your notes, you write that the development of like such a problem, may have been affected had the child been brought to the hospital sooner.
Yes, I think, identification of a problem and then evaluation and treatment of that problem would absolutely, yes.
Okay. Okay. You said it could potentially change the outcome. How is that? Like the treatment could reverse, or not reverse, but like help prevent it from getting worse?
Yes, I believe that, yes, if he was treated in a timely manner, the medical professionals might be able to slow the progression, of that, injury as a result of lack of blood flow and oxygen delivery.
Okay. It seems like when we're talking about the abusive head trauma, the shaken baby stuff, it's the brain moving around in the skull, right? That leads to the bleeding and the swelling.
Yes.
And you had testified that often that can be from acceleration or deceleration.
Correct, yeah.
Like a back and forth movement.
Yes.
It also can come from like impact as well.
Yes.
And something like in this case that, we don't have any evidence of like, skull fracture or anything, right?
That's correct, yeah.
But this type of injury could be caused from an impact with like a soft surface,
Potentially.
like a couch or a mattress.
Yeah.
Okay. Let me ask you about further these types of injuries. Could this be caused, if a child is like aggressively picked up from the armpits and like rocked back and forth?
I would expect the injury would be violent and repetitive as well. So I don't think that it would occur from typical.
What about if the child was picked up and the child's head hit something like the person's arm?
If that was the only injury, I would not expect this to extend to injury.
What about, and I'm going to ask you if all these things in combination, I'll just save the suspense, could possibly add up, right? What about picking up the child's head without support and the head like flop back?
Again, I would expect it to be repetitive. So I would not expect this pattern of injury with that history.
What about dropping the child onto a bed?
Again, I wouldn't expect it to extend to injury.
But dropping a child on the bed, that could lead to the brain moving around, right?
Yes.
And once that brain moves around, that can lead to swelling of the brain?
Well, if there's injury to the brain tissue, cause that swelling.
Right. So, and I had asked you earlier if the brain could move around and like that type of scenario and impact with a soft surface. And you said that the brain could do that. And then also, I guess that leads from it that the brain could, there could be bleeding from that kind of impact as well, right?
Yeah, well, I think that bleeding from the movement of the brain inside the skull, yes.
Okay. And I mean, all the actions I'm describing, in some way, there's like a lack of support to the head, right?
Yes, so the head would be basically able to move somewhat freely.
And that's part of the problem with shaken babies is that the head is not being supported while something else is happening, right?
Well, yes, there's repetitive again forces being applied to the child's head.
Right, and if there's not support to, stop the acceleration or deceleration, that's when problems arise.
Yes, that's when that bleeding happens. That's when the injury to the brain and swelling can occur.
I heard you say that you had a diagnosis. It was like a most likely diagnosis. I'm gonna have to ask you what that means, most likely diagnosis.
So I was not present and did not see immediately, before or kind of what the inciting event specifically was. But in, again, evaluating Daryl Jr. while he was in the hospital, there was what we call a differential diagnosis. So which is basically a list of possible problems that could lead to his clinical presentation. Through the course of his hospitalization, through the imaging, the lab testing, then the medical team was able to, rule out some of those possibilities. And then some of those, studies also provided support to other possibilities. So once everything was completed and injuries that I outlined previously were found, I believe that abusive head trauma is most likely diagnosis.
And we had talked earlier about like limitations in coming up with something. Were you able to read any police reports?
No, I only read police reports.
Did you have access to any statements from the parents as like the investigation went on about, admissions or statements about what happened?
I believe, yes, that I had just conversations with police about some possible histories or mechanisms of injury.
Okay. Thank you, Doctor. I have no more questions.
All right, any redirect?
Just a few. Doctor, how important, if at all, is the history you receive from, let's say, a caregiver or parent when a child comes to the hospital?
So I believe it's important, so that, that medical professionals can, kind of tailor the treatment, to, or again, kind of move those, potential diagnoses, around in that list of what's more likely. So if we're given a history of an injury or a potential injury, then, we might be able to kind of look for additional injuries, or again, kind of potentially get to imaging and diagnosis sooner.
So would it be fair to say that it's important that history is as accurate as it possibly can be?
Yeah.
Thank you. You were asked about kind of different scenarios where the baby's head might hit a person's arm, where the head might not be supported. Would any of that describe or be consistent with the injuries that you saw in Daryl Jr.?
No.
Including the fracture to the tibia?
That's correct, yes.
And you were asked why you call it a most likely diagnosis. And of course you said it's because you weren't there, you didn't see what happened. Is that common in your field of work, is that there aren't people who are what we would call witnesses to what happened?
That's correct.
Thank you. Nothing further, Your Honor.
Can I ask one follow-up, Your Honor?
You may.
Doctor, you said you had access to the University of Michigan records. Did you also have access to the records created by Tia Braxton?
I believe so. She is part of the maternal infant health program.
Well, she is the at-home social worker that does the home visits. And were you able to review those as well?
Yes.
Did you review the notes for the day that Daryl Jr. was admitted to the hospital?
Yes.
And are you able to share what those notes say?
I'm going to object, Your Honor. At this point, that's hearsay unless there's some reason there's not.
Response.
Well, I'm just trying to figure out how what's in those notes plays a role in her diagnosis.
No, I get that, but I'm going to sustain the objection.
Okay. I guess we'll have to ask her.
Thank you. Anything else, Ms. Tan?
No, thank you, Your Honor.
Thank you, doctor. You may step down. This witness can be excused. No objection. This witness is excused. You may call your next witness.
You will call Dr. Carl Schmidt.
Take a seat, raise your right hand. Do you solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth? So help you God. State and spell your first and last name for the record, please.
My name is Carl, C-A-R-L, Schmidt, S-C-H-M-I-D-T.
You may inquire.
Thank you, Your Honor. Hi, Dr. Schmidt. Thank you. Good afternoon. Thank you for your patience. Dr. Schmidt, could you please tell the court where you were employed in August of 2024 and in what capacity?
At the University of Michigan Department of Pathology, the professor of pathology, also deputy Washington Continental Exam.
Thank you. Could you please tell the court about your educational background and training?
I'm a physician, licensed practice resident in Ohio, Michigan, and Washington State. I have residency or specialty training in anatomic and clinical pathology. Then I have subspecialty training in forensic pathology. And I am board certified by the American Board of Pathology in anatomic, clinical, and forensic pathology.
Thank you. Your Honor, if I may approach and I'll show defense counsel what's been marked as people's proposed exhibit number 3. He was also sent that before the hearing today.
Exhibit 3, yes, you may. Go ahead.
Dr. Schmidt, I'm handing you what's been marked as people's proposed exhibit 3. If you could please tell the court if you recognize what that is. Thank you. Your Honor, I would move to admit the CB, people's proposed exhibit 3.
Any objection or voir dire?
No objection.
CB is admitted to exhibit 3.
Thank you. Dr. Schmidt, have you testified in court before?
I have
Approximately how many times?
at least 400 to 500 times.
Have you been qualified in court as an expert before?
I have
In what field?
mainly anatomic, clinical, and forensic pathology.
Thank you. Your Honor, at this point, I would move to qualify Dr. Schmidt as an expert under MRE 702.
Any objection, voir dire? Pardon?
No, Judge.
All right.
That's a lot of court appearances.
All right. And this witness is so qualified.
Thank you. Thank you, Your Honor. Dr. Schmidt, could you tell us a little bit about what forensic pathology is?
Forensic pathology is the branch of pathology that studies how and why people die, the changes that occur in tissue as a result of the process of death.
This is where the case enters its most definitive phase. Forensic pathology does not deal in possibility. It deals in cause and manner of death. Dr. Schmidt's role is fundamentally different from prior witnesses. He is not evaluating symptoms or treatment. He is determining what ultimately ended this child's life. Jurors often perceive forensic pathologists as the final authority because their conclusions are based on direct examination of the body itself. No memory, no perception, no bias shaped by unfolding events, just anatomy and injury. This testimony narrows the case dramatically. While earlier experts focused on injury mechanisms and survival, forensic pathology answers the ultimate question: why did this child die? Once cause and manner of death are classified, the legal conversation shifts from medical uncertainty to criminal responsibility. Ask yourself, when cause of death is determined by forensic science, how much doubt is realistically left?
Not only with trauma, but also with natural disease. And we also look at laboratory testing.
Thank you. And as part of the position you had in August of 2024, and I'm sorry, August and September, I should say, of 2024, did you perform and supervise autopsies?
Yes.
Could you just briefly tell us the procedure for autopsies?
So the autopsy is basically consists of two parts. The first is where you do a basic general exam of the body that includes things like height and weight, as well as looking for evidence of disease as well as injury. And after you're done with that, then you proceed to what is probably more popularly thought of what happens during an autopsy, where you open the cavity of the head, chest, abdomen, pelvis, and look at the internal organs, and you make a correlation with what we see in the internal organs and the external if that as well.
And did you supervise the autopsy of Daryl Hicks Jr.?
I did.
And as a part of the autopsy process, would you complete a report documenting findings and conclusions?
Yeah.
Was a report completed in this case?
Yeah.
Was it completed at or near the time of the autopsy examination?
It was sometime after the autopsy exam because there were several procedures that we had to do that were started at the time of the autopsy, but could not be completed until later.
Okay. And I'm going to ask you a little bit more about the procedures in a moment. Before I do, Your Honor, may I approach, again, I'm showing defense counsel what's been marked as people's proposed exhibit number 4, but he should have that as part of discovery.
All right. Yes, you may approach.
Thank you. But Schmidt, I'm handing you what's been marked as people's proposed exhibit number 4. Could you please tell the court if you recognize what that is?
This is a copy of the autopsy generated in the case of Daryl Hicks.
And how do you know it's associated with the case of Daryl Hicks?
Because it has his name on it and it has an autopsy number generated as part of the Washington County Medical Examiner record keeping. It also has an autopsy number, which is the way that it's kept track in the Department of Pathology and State of Texas.
Thank you, Your Honor. At this point, I would move to admit people's proposed exhibit number 4 into evidence.
Any objection or voir dire?
No objection on that, Your Honor.
All right, exhibit 4 is admitted.
Thank you. May I approach with exhibits 3 and 4, Your Honor, to publish? So Dr. Schmidt, I'm going to ask you some questions about that report, but before I do, at the conclusion of the examination of Daryl Hicks Jr., was there a determination as to the cause of death? And what was that determination?
Abusive head trauma.
This is the most consequential sentence of the entire hearing. Not suspected, not possible. not consistent with abusive head trauma. From a legal standpoint, this classification transforms the case. Accidental death theories collapse. Natural causes are eliminated. Medical mystery disappears. What remains is force inflicted by another person. The pathologist explains the injuries in anatomical detail. Subarachnoid hemorrhage, subdural hemorrhage, diffuse brain swelling, hypoxic injury. These findings independently point to trauma. Together, they remove coincidence from the equation. Importantly, the doctor does not claim to know who caused the injuries. That distinction protects the integrity of the testimony. Courts rely on experts who stay within their lane. At this moment, the jury's future task becomes clearer. Determine whether the defendant is criminally responsible for injuries that medicine says were inflicted. Audience reflection. Once death is ruled abuse-related, what alternative explanations remain plausible to you?
And was there a determination as to the manner of death in the case of Daryl Hicks Jr.? Could you please tell the court what injuries you noted on Daryl Hicks Jr. specifically that led to those determinations?
Well, the first is that he had something called diffuse subarachnoid hemorrhage. So the brain is covered by a very fine membrane, which has a very rich blood supply. And when that membrane becomes a little bit hemorrhage, that's what we say that it's subarachnoid. So basically, the entire surface of the brain was painted with this subarachnoid. Then there were scattered subdural hemorrhages. Basically, there was a subdural hemorrhage is a hemorrhage that is a clot that occupies the space between the skull and the surface of the brain. So a subarachnoid hemorrhage will sit on top of a subdural hemorrhage will be sitting on top of a subarachnoid hemorrhage. So it's a sandwich, if you will. You have the skull, then the subdural space, then the subarachnoid, and then the brain itself. Another way to think about a subdural hemorrhage is that when you open the skull, you peel away a subdural hemorrhage, whereas a subarachnoid hemorrhage is painted on the surface of the brain. A subarachnoid hemorrhage is an indicator of trauma. And in this case, it was basically all over the surface of the brain, called diffusely spread across both hemispheres, especially more weighted towards the left side of the brain. But the subdural hemorrhage extended down to another structure of the brain called the cerebellum, which is kind of like a smaller version of the brain that's seated next to the brainstem. So I guess the long and the short of it is that there was extensive subarachnoid, basically covering the entire surface of the brain, except for a small patch. Then there was what we call diffuse hypoxic ischemia. What that means is that the brain was deprived of oxygen because of decreased circulation. When this child suffered the trauma that resulted in all this hemorrhage, there was inflammation of the brain. And as the brain swells, there is an increase of pressure within the skull. The skull is basically a hard enclosure. And as the brain tries to swell, well, there's not much room for the brain to swell because the skull is itself helping to contain the pressure that builds up. And at some point, pressure builds up to the point where it exceeds the ability of blood pressure to pump blood through to the brain. So that we call the hypoxic injury, which is basically that loss of blood flow that happens to the brain as the increase in pressure within the skull impedes the ability of blood to flow into the brain. I hope that's.
Thank you.
And then there were patches of hemorrhage within the cortex. You will see that the autopsy report, there's something called diabetic confusion. What that means, it's a bruise that happened because of tearing or sliding of the cortex over the white matter inside the brain. It's basically two layers of brain with different densities sliding over each other as the trauma was inflicted. And when that happens, there are blood vessels that are keeping those two layers of the brain together, and they get torn. So you get the hemorrhage, which we call shearing contusion. Then there was the hemorrhage in the optic, in the retinas and the optic nerve. So to do that, we look at the eyes directly, and there was hemorrhage within the retina, which is the pigment, that black pigment layer in the back of the eye. Like that was also infiltrated. Hemorrhage. There was hemorrhage in the optic nerve, the right optic nerve that comes out of the eye. And there was also hemorrhage in the neck. At the spinal, there are 7 cervical vertebrae, and in levels 5 and 7, there was hemorrhage in the nerve roots that come out of the vertebrae, out of the nerves at that, out of the spine at that time.
Thank you. Did you note anything in particular regarding the essentially the skeleton, if you will, like bones? Was there anything noted?
No, and well, not in the head, but there was a fracture of the right tibia, injury to the growth plate.
Could you tell us a little bit about that, please?
So it was in the bottom of the tibia, what we call the distal tibia, which is to the ankle, to the knee. And basically there was trauma inflicted to that part of the leg, which resulted in breaking the growth plate. And you can see that there was hemorrhage in the growth plate, and we actually removed that part of the leg and took sections from it to look under the microscope. And you could see that there was hemorrhage there.
So going back to the injuries you observed in the head, what does that indicate to you? What does that suggest to you may have happened to cause those injuries?
You can think of injury as a transfer of energy to tissue. There is no injury that happens without hemorrhage being transferred to tissue. So this is a pretty extensive injury. The diffuse subarachnoid subdural hemorrhage, intense swelling of the brain that caused the pressure of the brain to rise to a point where it basically impeded blood flow into the brain. All this is a catastrophic event, which leads me to think that something really bad happened in this child very acutely.
The word acute matters enormously here. Acute means sudden, immediate, not gradual, not progressive over days. This testimony undercuts defense arguments built around extended timelines or delayed symptom recognition. Catastrophic injuries declare themselves. They don't whisper. For jurors, this reinforces earlier medical testimony about rapid onset. It aligns CT findings, MRI findings, seizures, and collapse into a single violent event. Legally, this tightens the circle of responsibility. If the injury was acute, then the person with care at that moment becomes central. Ask yourself, how much time would have to pass before acute stops meaning immediate?
I can't tell you exactly what it was. For several reasons. One, this child had actually survived for 8 days, 6, 7, or 8 days after he was admitted to the hospital. But this child was either shaken, that's one possibility, or his head was impacted against a padded surface. A padded surface would help spread out injury, and thus you would not see any injury on the skin as a result of being struck on a padded surface.
When you're conducting these examinations or supervising them, do you also consider the history of, did this child have a normal birth? Have there been any previous issues prior to the onset of symptoms that led to this? Okay. In this case, was there anything that had occurred, to the best of your knowledge, that would lead to these injuries from the medical records prior to this child coming to the hospital in August and September?
It was not.
And how does that play into your diagnosis?
Well, it just lends weight to the diagnosis of trauma as being the reason behind all these changes.
And you mentioned, you used the word acute. Could you describe to us what you mean by that?
It means that a lot of this happened in a very short period of time. This child was apparently well until the moment that he wasn't, and then he developed seizures, became abducted, and was taken to the hospital. This happened within a very narrow period of time, which is supportive of the fact that this was a major injury suffering.
I do want to ask you about going back to the tibia, the right tibia. And you noted acute fracture of the distal metaphysis at the, I'm not going to try to pronounce all of that, but I'm referring to page 8 out of 10 of your report.
Okay.
What type of movement might cause that kind of injury to the tibia?
What? Hold on one moment. Young man. Yep. Side, Miss Tanner.
I'm sorry, Your Honor?
Might want to move to the side. Bring him up here. What's your name?
Ashton,
Pardon?
Ashton.
I gave a warning. You were in here when I gave the warning. No, don't even try it. I saw how you walked out. I saw how you looked at him. I saw how you flipped your head. I didn't want to see that. I asked that everybody be respectful to everybody else. All right, so if you come back in this courtroom ever, you make sure you behave yourself accordingly. Understood?
Yes, sir.
You can go.
Doctor, I'm going to ask you this question again, referencing page 8 out of 10 of your report regarding the right tibia. What type of movement might cause that type of an injury?
This can only be caused by one of two things. One of them is the leg was impacted against the surface such that it caused the growth plate to get displaced. This is not a fracture like an adult where the bone hits something and because of the impact at that point, the bone splits. This is cartilage. It's growth plate. So instead of bone kinking, it kind of gets displaced, like shearing one end of the tibia over the other. And the other possibility is that it was squeezed. That's how we think these things are fractured.
Would something like a light squeeze cause a fracture like that?
No, to move, cause a fracture like that, paralysis, I think requires significant amount of pressure.
This statement is critical for intent analysis. Significant force means this wasn't a slip. It wasn't a reflex. It wasn't a momentary misjudgment. Courts evaluate intent not by thoughts, but by actions and consequences. When force reaches a level known to cause severe harm, intent can be inferred from conduct. This doesn't mean the defendant intended death, but it does mean the law may infer intent to cause serious physical harm. And that distinction matters for first-degree child abuse and second-degree murder. Audience reflection. At what point does force become so dangerous that intent can legally be inferred?
Thank you. Nothing further.
All right. Cross-examination.
Doctor, so I want to ask you about the potential of blunt force impact. I think your testimony was that, this could be shaking, this could be a blunt force impact that couldn't be excluded. Could you describe what is a blunt force impact?
Blunt force impact is when a body part strikes an object such that it can leave behind a bruise or not, but there is no actual breaking. So for example, if I strike you with my fist, that would be an example.
Okay. And that cannot be excluded in this case.
Correct.
You spoke about, in the blunt force impact, that would be an acute occurrence, right? You talked about how injuries are the result of like an energy transfer. I'm sorry if I didn't use the right words that you said.
That's correct.
How much force are we talking about that would be required to produce such an injury?
I can't tell you in numbers what actual force is needed. There is literature from the motor vehicle industry that have looked at how much energy can be generated in a motor vehicle accident. You can find the dummies, for example. But in this case, suffice it to say that this is a significant injury that required a significant amount of force just because of the extent of the injury as well.
And I think you had talked about how the injury is so diffuse. Could that be related to the blunt force impact on a soft surface, making it so diffuse?
Yes.
Okay. You had said that it would be a significant amount of force to result in the injury in regards to a blunt force impact, but you're not able to describe, like in numbers, what that would look like. Are there any studies or anything out there that you could point to help me read on this that would describe that, or do we not have that?
As I said, the motor vehicle accident literature does have references mainly regarding crash testing and the like. Okay. But this is not something that you can actually do because you can't.
Right. So it's fair to say there, and if I'm hearing you right, there's not studies on this because it's impossible to actually study it.
Correct.
There's estimates, but we don't know for sure. Let me ask you the same thing about potential shaking. I mean, do we know what type of force would be required in a shake to cause an injury?
No. No, there are papers that talk about not just the energy, but how fast the head needs to vibrate and so on. But it's obviously an experiment that you really can't do. What we know about shaking is because there have been published articles by pediatricians such as Suzanne Starling that look at cases of subdural hemorrhage with swelling of the brain that were taken from individuals that confessed actually doing this. And their value lies in that many of these stories were actually, many of these descriptions of shaking were actually obtained before there was a diagnosis of shaking.
So okay, if I could sum up then, it's fair to say that we can't say that such a shake would cause such an injury, right?
That's right.
And there's no way to really get a firm answer on that.
Right.
But you can say with medical confidence that it could be, either a shake or either a blunt force impact.
Right.
Thank you. Those are all the questions that I have.
Can you redirect?
Just briefly, Arnold. Doctor, I want to ask you about the fracture again to the right tibia. Was that fracture a fracture that had healed as if some time had passed, or was that a recent fracture?
Recent.
And as far as you were aware, and at the time you performed this, or as you're sitting here now, Daryl Jr. was never in a car accident.
Right.
Thank you. Nothing further.
All right.
No other questions on that, Your Honor.
All right. Thank you, doctor. Right. How many more witnesses do you have?
Your Honor, I actually have no further witnesses, and I was going to ask, I've had, Deputy Singer waiting, and I'm not intending on calling him, so if he may be excused, I'll make sure he gets home.
All right,
Well, I'm gonna call Deputy, or sorry, Detective Yeager then, if Ms. Tanha's not going to.
all right. So why don't I do this? While we prepare for that, you can then release your witness. I'm gonna take a brief recess. And we'll come back and we'll continue. Court is standing in recess. Back on the record in the case of the people of the state of Michigan versus Darrell Hicks.
Good
And
afternoon, Your Honor. Marie Tanhas, assistant prosecuting attorney on behalf of the people.
Sam Bernstein with non.
all right, and the people have no more witnesses and have rested. Mr. Bernstein,
I'm going to be calling Detective Brian Yeager to the stand, Your Honor.
all right, very good. Sir, please come forward and be sworn.
Testimony about the truth, the whole truth, and nothing but the truth, so help you God. States the book, the first matter, and the rest.
My name is Brian Yeager, Brianyeager.
All right, you may inquire.
Good afternoon, Detective. I know it may be somewhat odd for defense counsel to call the OIC when you were otherwise not called, but here we are. So this was a case that you were the investigator on, right?
Yes.
And you had several occasions to speak with Mr. Hicks.
Yes.
And on one of those occasions, that was at the Washtenaw County Sheriff's Department.
Yes.
He had come in, I mean, this is a prelim, so he had come in to do a polygraph test, right?
Yes.
And there was like a pre-interview session with Detective Babbage before that.
Yes.
And you were like observing that session.
Yes.
And you heard the conversation that was made during the conversation.
Yes.
And you ultimately wrote down that conversation in your police report, right? So, Mr. Hicks says some things that could be considered admissions against his own interest, right?
I'm gonna object as to counsel characterizing what the statement may have been interpreted as. I think there's a more direct question. Yes.
Any response to that?
I mean, that's fine. I can rephrase it, Your Honor, if that,
Thank you.
I thought I was skipping
Take
a
the
step.
objection, rephrase.
What did Mr. Hicks say regarding,
I'm gonna object, Your Honor, hearsay.
Yes. Response?
let's try again, Judge.
For what?
Did Mr. Hicks make any admissions that day?
Yes.
What did he say?
Objection, Your Honor.
Sustained.
Judge, why can't I ask what,
Because it's hearsay.
but there's statements against his own interests?
It's classic hearsay. That's one of the reasons why it's hearsay, because you can't get the testimony of the defendant in by that means. He would have to waive his right, because what protects him is his right to not testify. So you can't get his testimony in by taking it through some other means. It's hearsay. That's why the rule's there in Great Park.
But it's,
So the objection is sustained. You can argue with me all night long if you want, but I'm telling you, it's still gonna be sustained.
I just only wanted to argue for 2 more minutes, Judge. But generally speaking, when police officers get up there, they talk about what the defendant said,
Because they're not the ones.
because the prosecutor's calling them.
Your Honor, if I
Yes.
may clarify, victim is not considered a party.
Yes.
Counsel is, as I would presume, on the side of the defendant as he's representing him, not a party opponent.
Correct. That's one analysis. See, the other was the one I gave.
Oh,
But-
I guess, I can't get what I want to get in, and Ms. Tanner made a good move by not calling Detective Yeager, so I think we're all done.
Appreciate the compliment, Your Honor. Nothing further.
From this witness. All right, thank you. You may step down. Thank you. I think that's the shortest time you've ever been on the stand before. All right. Any additional witnesses for the defense?
There you go.
Do I
At
have
this point, we would move forward by and over on all the counts in the
response?
I do have a response, Your Honor, and I, of course, didn't get as much in as I was hoping to. which somewhat undercuts me, but it is what it is. Look, I mean, the first degree child abuse cases, People v. Maynor is the law. And that is, it's not just that a person might have an intent to commit an act. The person must intend to commit the injury that followed that act.
Here the defense makes its strongest legal argument. Michigan law requires intent to cause injury, not just intent to act. This is a high bar, but intent does not require confession. It can be inferred from circumstances, severity, force, timing, response, and silence. The judge listens carefully because this argument determines whether the case goes to trial at all. Ask yourself, should intent be measured by what someone says or by what their actions cause?
And that's from People v. Maynor 470, Mich. 289. And, Dr. Schmidt just testified, he said to cause an injury would be significant force, but we don't exactly know what amount of force a shake leads to an injury. We don't exactly know how much force a blunt force impact would have to cause an injury. The distinction here when we're talking about first degree child abuse is that the person needs to intend for the injury that follows from an act. And that's what's not on the table for Your Honor to consider. There's no admissions for Mr. Hicks. There's no witnesses to an act. And we don't have anything that shows that, even at a probable cause stage, there's just nothing on the table that shows he had an intent to create some sort of injury from an act.
Going to be an issue for the jury.
Well, I think it's also
making the argument that I'm to try to figure out his intent. I couldn't make that determination anyway at this stage. That's for the fact finder. That's clearly a question.
Of course, the jury instructions say knowingly or intentionally caused the injury. And so there has to be, in the Maynor case, says more than intent to commit an act, the person must intend to commit the injury that followed the act. And that's what's not present here. And that's what I'm arguing is needed for a bind over, Your Honor, that there needs to be that intent to commit the injury. That's what knowingly and intentionally committing an act leading to serious physical harm means. And that part is in the jury instructions in the statute, Your Honor. And so that's what's not present here. And my argument is that without that, there's no first degree child abuse that has been shown. There's not been shown proofs that there was intent to commit that act. They're not knowingly or intentionally would be the language.
But Mr. Springton, if by something occurring to this child, which it did, and not immediately contacting his primary caregiver, that being his mother, that could be an indicia of some intent on his part, but not something I can decide here. I mean, that's what I'm getting at. I mean, you can argue, but that's clearly a question of fact. And
I hear what you're saying, Your Honor. I think there was some evidence that there was a meeting with a medical person at the home where this was discussed. And Dr. Parkin Joseph said that medical neglect played a role in some of the injuries that were here. And I mean, a medical person saw the baby. He was not instructed to do something otherwise. So I think there is something there, Your Honor, that shows that, he brought this up to someone and laid it out there and was not told otherwise. So it's not, did he call mom? I mean, he told an at-home social worker.
Okay, but it's still not something I can resolve.
Well, I understand the constraints that Your Honor is faced with the factual presentation here. I don't think there's enough elements there for first degree child abuse. And the charges that flow from it, I don't think can go either, Your Honor. So that's the basis of my argument.
Any response? I don't necessarily need it, but go ahead.
Not by way of argument, I do want to make a clarification because we are going to have a transcript. So I want to be very clear.
Yes.
There was no testimony from Dr. Parkin Joseph that this was medical neglect. I want to be very clear about that.
But I think there was like a contribution of medical neglect. I mean, she said it was in her consultation notes, Your Honor.
Your Honor, it was considered, and we are all very happy that she considered all possibilities and then jumped straight to abusive head trauma. So yes, it was considered. That is not the cause of Stacy's injury. She could not have been more clear. Thank you.
I would ask the court to please consider my arguments. I think I'm on point. I think it's in this, I think Maynard supports my argument, Your Honor. Thank you.
Well, then I'll start with count two, since that is the predicate offense really for count one. The court believes that there is sufficient evidence to, first of all, he's the only one in the care of this child, the only one that, at least by the testimony that the court has before it, has access to this child. It is clear from the medical testimony that during that period in time, between the time that the defendant has care of that child and then mom returns to get that child, something acute, something traumatic happened to this child. On that, quite frankly, the court believes that it may be up to a jury to decide what the defendant may have known at the time, what he may have done knowingly or didn't do knowingly. But those are all questions to be decided by a jury. I can't make that determination here. Further, to the extent it needs more analysis, the issue of one's intent can be shown by what they did, how they did it, what they didn't do, what they said, what they didn't say. Any other facts and circumstances can be used to show someone's intent. A jury could come back and determine by his lack of saying anything, his lack of contact, and I'm not saying that they should or shouldn't, but a jury could come back and make that determination that he intentionally did this because something had happened to that child. Again, that's up for the fact finder. But for the purposes of probable cause, given that that could be what a reasonable fact finder could conclude based upon what I have before me, I think the people have indeed sustained their burden of showing the necessary to show the offense of child abuse in the first degree. And so therefore, the people having shown that to sufficiency for this court, I would bind the defendant over on count two, since it is a predicate offense and there was indeed a death involved. Then the court would also bind the defendant over to stand trial on count one. And the court also does believe that there is sufficient evidence shown by the testimony in this case that the defendant properly would be bound over and should stand trial as to count two, murder in the second degree. Therefore, the people having sustained their burden, the defendant is bound over to stand trial on all three counts.
This is the legal threshold moment. Judge Simpson is not declaring guilt. He is declaring that a reasonable jury could find guilt. The judge explains that intent can be inferred from actions, inactions, and surrounding circumstances. That is textbook law. This ruling sends the case forward because the evidence meets the probable cause standard, not because the outcome is predetermined. Audience engagement. Do you believe probable cause is an appropriate threshold for sending a case like this to trial?
May I approach to sign the information?
In my calendar, Your Honor, I have a copy of the information, waive any further reading, stand mute.
Defendant having waived formal reading, standing mute to all three counts, court will enter a not guilty plea. Pretrial will be set for
June 30th at 1:30 p.m. Judge.
June 30th, 2025, 1:30 before Judge Coe.
June
Do I
30th, Your
believe it's
Honor?
a Judge Conlon case?
I do have Conlon here. Where you, well, I have the file marked up.
I was just going to read the splits, but if your file says Conlon, I can give you one.
Thank you.
Looked like Concan, my little spreadsheet thing.
It looks like it on your, oh, no, I have this as Conlon.
Okay, Judge Conlon is July 2nd at 1:30.
July 2nd, 2025, 1:30.
With dates set, the courtroom transitions from hearing to preparation. Motions will be filed, experts challenged, evidence contested. What you've watched here is the foundation, not the conclusion.
Before Judge Conlon.
Thank you, Your Honor.
Ron will continue as said. Thank you.
This preliminary hearing was never about verdicts. It was about whether evidence justified a trial, and the court ruled that it does. Medical experts established catastrophic, abusive injuries. Forensic pathology confirmed cause of death. The judge determined that intent and responsibility are questions for a jury. This case now moves forward with the full weight of law behind it. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.